Good morning. Thank you for joining us. Today is Wednesday, February 2nd, 2022, Lee County Board of Commissioners zoning hearing. If you could please stand for the Pledge of Allegiance. Pledge of Allegiance to the flag
of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Please be seated. We have two cases this morning. Anthony, would you like to start off the first case?
Yes, sir. Good morning, Commissioners. We have two cases this morning. The first case this morning is DCI 2021-00010, Parker Lane RPD. I'm going to introduce to you Dirk Danley Jr., who's going to summarize the case for you and will be available as the staff liaison to answer any questions for you. Dirk?
Good morning. Once again, my name is Dirk Danley. I'm a senior planner in the Zoning Division of Community Development. The first case you have today is Parker Lane RPD. The request is to rezone approximately 18.55 acres of land zoned agricultural to residential plan development to allow up to 90 single-family residential dwelling units. The hearing examiner recommended approval with conditions, and there were 3 participants of record. And staff and the applicant are here for any questions that you may have.
Great, thank you. Any questions for staff at this time? Nope. Okay. Would the applicant wish to address the board?
Neil Montgomery for the record. I don't really have a presentation. We agree with the staff report, but if there are members of the public here who raise issues that they raised before, we'd like the opportunity to address those. Do you guys have any questions?
One simple.
Commissioner Mann?
From the overhead we're looking at, what is it that looks like water?
Pardon me?
What is it that looks like water?
A lake?
A lake.
To be created?
Yes. but
Looking at
there's-
a house on
there's
what I'm-
cows on the property now, so there's some areas where they drink.
So that will be a huge retention pond?
Yeah, and just so you know, there was the hearing examiner during the hearing had a question about drainage because the property owner to the west raised some concerns about their drainage ditch and that it wasn't maintained well. So Mr. Fitzgerald's here, but he looked at the site, and the site's now engineered to go over to 6 Mile, essentially, and south, so that nothing on this site is going to impact the people to the west who have issues.
So this is to retain water. The surface flow is not going to be affected.
Where is it? I'm going to have Mr. Fitzgerald, who's an engineer, if you can have
If you don't mind, just
questions about the
some
drainage.
understanding of that's a major change in the surface.
Good morning. For the record, Drew Fitzgerald. So there is a lake that's designed, it has to meet South Florida water management criteria, and then it's going to ultimately drain down J.B. Parker Lane to the east. But it's basically the lake that collects all the stormwater from the development, treats it, and then releases it with a controlled release down J.B. Parker.
Okay, so the water district is requiring this.
It's required, yes.
Okay, so this is an improvement.
A necessary improvement.
Retains and treats and releases
Control.
surface water.
That's correct.
And what I'm looking at right now is it appears to be houses or barns or something there, which would be gone, obviously.
Correct.
Okay, thank you.
You're welcome.
Were there any other questions?
Yeah, I have a question. So I know the area because it's north is, I think, is Penzance, where you had that multi-unit apartment complex there at the top of the, when you actually see the blight. But the bottom right, is this, this is the building here, is that the one that faces 6 Mile Cypress now? It's like the
I'm sorry, I can't, you're pointing
I
at
don't
your,
know if somebody from staff knows that building, the bottom right on that. That's the building that faces 6 Mile Cypress, correct?
Yeah, that faces 6 Mile Cypress. It's Carissa Commerce is the.
Okay. So I'm just looking for egress and ingress. So the property was going to, the traffic flow is going to flow which way? Is it going to flow east out to the side road and back out to 6 Mile that way?
That's how the site is designed currently, yes. There's a secondary emergency-only access onto Blasingame. That's just going to be stabilized I believe it's stabilized grass for emergency access. There was a deviation request for that, but the traffic for the residential development intends to use Crystal Drive, yes.
And going back to what Commissioner Mann brought up about the lake, the new lake being there's two existing ponds, one on the southern portion of the property and one northern. Are those going to be incorporated with that? I actually believe the one on the south will not be incorporated with the new water drainage. So as far as like the wildlife that currently uses that pond now, would that be removed and put into the new lake, or is it a newer lake that has no wildlife in it?
I think both of these are used as agricultural lakes, or they were previously
Okay,
used.
so not that deep, it's just shallow for water for cattle grazing, cattle grazing, okay.
That's my understanding, yes.
Okay, thank you. Thank you, Neil. Okay, this time we'll call for public comment. The first participant, we have Bill Innan.
Good morning, Commissioners. Richard DeWitt on behalf of the property owners, Carissa LLC and 6 Mile Partners. Mr. Enneman is here. He was the one that appeared before the hearing examiner. First, as a procedural matter, I think I spoke with the planner. The applicant on this particular parcel has failed to comply with the notice requirements set forth in the admin code 2.8, which requires that the property be posted prior to the hearing examiner, which they did supply an affidavit, but that posting needs to be up for this hearing as well, and to my knowledge, that hasn't occurred. So I would defer to the county attorney's office, but I think we cannot proceed if they did not comply with that.
We'll address that issue once his 3 minutes are up.
Great.
You have
Is
3
it
minutes.
3 or 5? I think it's 5. Okay, I'll proceed. So again, we represent Carissa and 6 Mile Partners. They're the surrounding property owners and owners of Crystal Drive, which runs along their respective properties. They have always maintained this property and Crystal Drive as a private road. So today we ask that the board reverse the hearing examiner's recommendation of approval, or in the alternative, continue the public hearing and direct staff and the county's attorney's office to cull out this issue regarding ownership of Crystal Drive. Research and provide a legal opinion on the actual ownership of Crystal Drive. Again, the property owners have always maintained this property as a private road, and neither the applicant nor staff nor the hearing examiner looked at this. We provided a legal opinion from my partner Keith Polyakoff in a letter that stated and gave specific instances and background on why it is owned by, excuse me, Carissa and 6 Mile. Now, the applicants filing, throughout their filing and application, they utilize our property, Crystal Drive, for their entire project, and it's referenced throughout. And if you look at their own documents, their survey references and shows and indicates that there is a title issue as to Crystal Drive. Now, that reference is within their exhibit, page 21, attachment 6, which says that the title policy does not ensure the title to any portion of Crystal Drive. Now, the only reference the county staff has provided is the minutes from the 1920s, which is in Book 5, page 669 of the public records for Lee County. Now, that references, so back in the 20s, how roads were dedicated is there had to be a petition, and that petition went to the county commission. The county commission would appoint viewers. These were 3 people that would go out, view the road, and recommend the best route for that road. They would then come back, provide a report, and that report was either accepted or rejected. In this instance, the minutes clearly show that they did appoint the viewers, but the viewers never came back and provided their report, and the county commission back in the 20s never accepted it. So we maintain that there's no evidence. That's why we're asking you to send it back and ask staff to look at this more thoroughly. So again, that was the process back in the 20s, and there's no evidence that the county staff has provided, there's no evidence the applicant has provided, And there's no evidence that hearing examiner even addressed this issue. It was brought up to the hearing examiner, but they did not address it. So at this point, the property owner, Carissa and 6 Mile Partners, has not consented to or permitted the applicant to utilize their road for this project. So again, we would ask that you either reject the hearing examiner's report or you send it back to county staff and the county attorney's office to make the determination. Aside from that, the applicant is prepared to protect their rights under the Constitution, Florida Constitution, Article 10, Section 6, which safeguards private property rights from an unlawful taking. I thank you for your time.
Thank you.
Mr. Chair, real quick, could you show me what property you're representing? Just point to it on the map or something? Just so that I
So there's 2 properties. There's Carissa and 6 Mile. State your name for the record.
Yeah, Bill Ennin, for the record. The piece that we're representing, where it says Crystal, is to the south there. We built the
map there? You
Indicate that on what you look at in front of you.
There-
Anthony, can you help him
Anthony,
out?
there you go, you could,
Oh, you can
actually draw on it.
Okay. It's actually this piece right in here. And then Stephanie Miller has a group that I believe is this piece right in there as well. And then we actually go to the center line, so both of us. Our north property line touches Stephanie's south property line, right down Crystal. We're on this piece here, right there.
So it's the vacant land that's listed with Stephanie Miller and the other current parcel is already built on now, correct?
Yeah, we built a 55,000 square foot building, which is this one there, and then there's 2 out parcels facing 6 Mile, and then I believe Stephanie Miller is in for zoning on her piece to the north of Crystal right now. And then when we built our subdivision there, we ended up putting in the left turn lane on 6 Mile.
Your attorney's already took your 5 minutes up, but thank you. We got the picture. Commissioners, have any other questions about it?
no, that's.
No? Okay. Thank you.
Thank you for your time.
Next speaker is Stephanie Miller. Is Stephanie here? No.
Good morning.
David Richards?
The issues that he just raised were raised before the hearing examiner.
I still have people to call.
Oh, I'm sorry.
Stephanie Miller is not here. David Richards? Morning.
So I'm here to speak about just the Blasingame Road portion of this project. I live on Blasingame Road, and there's a proposed paved emergency exit onto Blasingame Road that when I talked to the fire chief, in the hearing examiner's hearing, everybody insisted that the fire chief was demanding that this road be paved for a paved emergency exit. I spoke to the fire chief, and he did not demand that, spoke emphatically about not demanding that. He said that he was given information that said it was going to be paved, and he didn't see anything wrong with it being paved, but he definitely did not ask for it to. And so I would like to see if you guys would reconsider and not pave that, thinking that if something is paved, somebody's going to drive on it, and that's what we don't want it to do, is have access to Blasingame Road. And the other thing was, we talked about the construction traffic for them to build this project, that because there is no access right now at Crystal, it's very tempting for them to use Blasingame Road, which is a private road, for them to use all their commercial equipment coming down to start the project. And we would like for that not to happen. It's privately maintained, there's no reason for that. And so the other question I have is, what would they have to go through if they bought some more property and this little L shape that you see there became a rectangle? What would they have to do to rezone or to add those parcels to this project?
This is your time for public comment. We don't have dialogue back and forth.
Oh, I'm sorry.
Okay,
So I have reason to believe, because I spoke to the owner, that they're going to include the 10 acres that is there, that is in the cutout. And I want to make sure that things go the same way that they went with the hearing examiner's office as far as density and heights and setbacks and all that other kind of stuff. Just seems that that would be fair. So that's all.
Great, thank you. That's the last public comment. Real quick, just to answer some of the questions. So the Blasting, and also staff maybe can answer, the Blasting Road, is that currently a private road now?
Yes, sir.
So, okay, just for, so public record, so knowledge, the county commission, we don't approve or disapprove. That would be up to the owners to come forward to have that road taken over by the county. That's something the owners would do. We don't approve that today or anything like that. There's no action. This is for the zoning action for the use of this property currently. These actions don't involve any of the roads, so that would be done later. That, and as far as any of the future properties being acquired, they would have to go through the same hearing examiner process as this is being done today for the hearing examiner. So that decision could not be given today either due to ex parte communications. So.
I wasn't asking for the road to be taken over by the county. I'm trying to get them not to use our private road for their project.
Okay, thank you, sir. Okay, applicant, would you like to address the board again?
For the record, Drew Fitzgerald, I'd like to address the last speaker's comments, if I may. When we were coordinating with South Trail Fire Department for support of a deviation for a single point of access, we coordinated directly with the plans examiner who works for the chief. The plans examiner told us that we would have to pave the emergency access, even though we don't typically do that. We typically just do a stabilized, sodded access whenever we do these emergency accesses, but that's what she was telling us. So when we got into the hearing examiner and the previous speaker was objecting to the idea of it being paved, not having any other communication with South Trail, we tried to preserve the right to do that. After the hearing, he took it upon himself to talk to the chief. I got word that the chief was saying that we did not have to pave it. I called or contacted the chief. The chief confirmed it. We've submitted for a development order. There's no pavement shown for the emergency access. So my client does not, or the applicant does not particularly want to pave the emergency access. It was simply some miscommunication between people at South Trail Fire Department. And we'd each just talked to two different people. So that's all. I just wanted to address those comments.
Thank you.
Could I ask a question?
Yes.
So, Drew, real quick, or Mr. Fitzgerald, does that mean if you're not paving it, then you're not going to be using it as a construction entrance and access then?
No, we've already agreed not to. We're going to use a construction entrance off of Crystal.
Okay, thanks. That answers my question.
Mr. Chairman.
Yes, sir.
I'm sorry, but I'm just thoroughly confused by several things that have been said here. And I'm not sure what the question is, but the first one is, clarify for me, what is the main entrance to this
Crystal Drive will be the main entrance to the property.
That's a street we're talking about right now, that we're talking
Yeah, I
about
think
paving or not paving?
I think Neil will address that further.
There's two streets.
Well, the allegation the other gentleman made a little while ago from Polyakov, is that who you represented?
Government law group.
Government law group. His allegations were sort of heavy.
Okay.
And
the
I
road would-
need somebody to bring that into a closing. I don't understand how you're going to get in and out of here. I don't understand how you're going to have 90 units back there on a non-paved dirt road.
Okay.
Help me understand what's going
Right.
on here. You're not doing a good job.
Mr. Fitzgerald and the gentleman in the back were talking about the emergency access on Blassingham, which is the road that I put the red line on. The Windstorm project, the Neal Communities to the west, has an emergency access on that road. And this project will have an emergency access. It will not be open on a regular basis. It won't be used for construction. It's just there in case the plane crashes and you can't get in the main entrance. The main entrance will be on Crystal. This is Crystal. Right now, there's a project to the south that you guys saw several times, Oak Village, that as you remember came here, got remanded, came here, got remanded, finally got approved, and they have submitted for development order to use Crystal. Crystal is on your county functional classification map as a county road. It is a viewer's road. These issues that the gentleman raised were raised before the hearing examiner, and the hearing examiner recommended approval and recognized that the main access will be off of this road, Crystal. Crystal on the county's long-range transportation plan is projected to go all the way over to Plantation. And in fact, if you were at Plantation, you made the Pulte Camelot Square project make a connection to Crystal because you expect that road to go through. At the hearing examiner, the real issue turned out to be a complaint that they think they should have gotten impact fee credits for building the part of the road they needed to their project. The county has a definition in their Chapter 10 and in Chapter 2 regarding impact fees about what is or isn't a site-related improvement. If you need that to get direct access to your site, it's a site-related improvement. And because it's a site-related improvement, they did have to pay for it. And when the project to the south and this project continue it further west, because it's a site-related improvement, they will have to pay for that as well. I'm guessing Mr. Loveland might say if somebody wanted to build it all the way over to Plantation, he'd give them impact fee credits, but until then, he's not going to. Am I right about that?
Well, that would be the board making that determination, but yeah, my recommendation could be credits if they're building it all the way through.
And at the development order stage, we'll have to submit a title certificate and all that information again. So the emergency access is on the north-south Blassingham. The main access is on Crystal.
Neil, so how long from that entrance on Crystal on the southern portion of the property, they'll be going east out to 6 Mile Cypress? How far is that by scale? It's like a quarter mile, probably or less?
I haven't measured it.
And that portion, just for the record, so that portion of Crystal Drive that's being accessed, is that public road or is it a county road?
I'm going to let Mr. Loveland answer that.
I'm sorry, could you?
Is that portion of Crystal Road that's accessible there, is that a county road or is it a private road?
I don't believe it's been turned over to the county for maintenance yet, but the intention is for Crystal to ultimately be a county road to connect all the way through, as Neil said.
Right, just for access and for maintenance, so are they required to maintain that then? Going to maintenance agreement with these property owners in the area?
Until it's turned over to the county for maintenance, yes. And it has to be built to county standards for the county to accept it.
Okay.
And just to emphasize what Neil said, the issue in front of you is the zoning approval. At this point, when they submit for a development order, they have to demonstrate that they have the legal right to access to that roadway. So that's the point at which they have to show that they have the right to access.
So the argument from the other council that they were not given permission to access this road during the hearing examiner, would that be something we deal with today, or would that be something done with development through the development stages?
They would have to do that at the development order stage to show they have the legal right to connect.
And I have to go back to the county attorney. So based upon the hearing examiner's case there for state, was it advertised legally? Is it sufficient?
Yes.
Based upon advertising from the county standpoint from the hearing?
Yes, sir.
And also, is it accessible to the road? I know they didn't respond to that in this recommendation from the HEX, but would that be something we deal with today, or is that something to do in the hearing through the development stages?
No, you're correct, and Mr. Loveland's correct. This is a issue that must be demonstrated at development order stage. If they do not demonstrate sufficient access, they will have to come back and amend their zoning to accommodate whatever new access, if any. The notice for this hearing is the newspaper required notice. The publication or the courtesy notice that is provided in the signs that are put up along the property are for the hearing examiner hearing, not this hearing, and they are only courtesy notices for the purpose of this hearing. Courtesy notices are nothing more than that. They're not jurisdictional. They're not required in order to proceed with this hearing. The newspaper ad is what's required, and that has been done.
Okay, thank you.
Do you have any other questions?
Any other questions for the applicant this time?
I still don't understand what's going on here. It seems upside down or premature at best. I'm very uncomfortable moving forward on this. These are the kind of answers that seem so fundamental and need to be answered clearly before we're approving zoning for something that the access is questionable. I can't support this. Y'all do what you feel you need to do here at this stage. It just seems upside down to me.
One of those cases where a few weeks ago we just had a discussion about having the HEX here. We could ask some questions of the HEX, but that's not possible today because we only have what's in front of us today. County Attorney, do you have any comments about the discussions today that was raised by either council?
most, if not all, zoning cases have issues with access as far as where the access points are ultimately going to be. In those circumstances, it is a development order issue. More often than not, though, you do not see in a public hearing for zoning somebody coming in and arguing over development order issues. That's why it seems a little bit backwards here. From our standpoint, there are questions as to access. They'll be discussed and addressed during development order stage. And if they're, like I said, if they're not, then additional zoning action will have to happen in order to make this happen. Or they work out with the property owners to make sure they have access.
Maybe I can make this easier. I mentioned the property to the south submitted for a development order. Our access point lines up with their access point, and they've been issued a DO. And they wouldn't have been issued a DO if they didn't have the right to use the road. So I don't expect the answer for our DO to be any different than the DO you've already issued.
So is the currently development order already issued from the other parcel?
Who's, if I may,
Mr. Mann.
who's going to fix the road? Who's going to improve it to county standards for access for these new 90 units?
The road will have to be maintained, as Mr. Loveland said, by the property owners until such time as it's turned over and accepted by the county.
Initially improved to county standards?
The road
By
has,
whom? Who's going to do that? The developer?
the county's going to make the road be built to county standards, and it will be maintained by the landowners until such times it's turned over and accepted by the county.
The answer to your question, Commissioner,
And we're building it, yes.
Wait, say it again, Michael.
developers are building it to county standard.
As is normally the case.
Correct.
That helps.
Thank you. Back to the board for discussion or some type of action or motion?
Commissioner, can I ask the county attorney?
Yes, sir.
Can you break this down to 2 points? It seems like they're convoluted. Can you break down the issue before us right now and then the subsequent issue we're going to have to deal with?
Yes.
Thank you.
The zoning allows for the particular uses. Access will be addressed at development order stage.
Right now, it's just the use.
Correct.
Yeah.
I know it's an oversimplification of the zoning process, but that's what it is.
Commissioner Sandelli?
I just felt like we got a little over the tips of the skis here a little bit, and I concur with the commissioner here. I mean, to break it down, we're looking at, you know, the use of the property, rezoning for the use. I think there's a lot of steps to go before you get through the development order, which allows the property to actually be developed. And so I think we got a little over the tips of the skis. I think there's a lot of pieces to go, you know, until we get to that point. So I understand the concerns and a lot of different things, but I think we just talk about use there. And if we keep the clarity on that, then I think that the rest of the issues will take care of themselves.
One more point. So really just, and I appreciate the county attorney stepping in, the questions we heard were A, notice, and we complied with that, and B, development use, which is going to be a subsequent time.
Correct.
Development order, I should say, at a subsequent time. Use is right now.
Correct.
Okay. Thank you. My questions are answered.
Mr. Chairman, one last effort here. Loveland, you okay with this? You guys are recommending it.
Yes, sir.
You're okay with this?
Yes, sir.
Michael?
Yes, sir.
Even though it's a little convoluted and unusual in the way we're approaching it.
As I indicated, it's not unusual. This is normally what happens. The ultimate access points, developments, there's so many more development standards that have to be met by these projects that aren't addressed at zoning time.
I'll buy that. I mean, I know we got a development order yet.
As Commissioner Sandelli indicated, we're sort of over the tip of our skis on this one, because these issues, development order issues, are all worked out at length during the development order review process between our office, staff, the applicant, the consultants, and you don't typically see someone coming at the zoning hearing talking about a development order situation. That's why it seems a little bit off.
But that's what happened here, and there was a pin pulled on a hand grenade by that gentleman, and it caught my attention, and as not the usual, they gave me an award for 15 years of dealing with zoning issues around here, And this is my first one with this hand grenade thrown in it.
I'm on my 15th year now too, and I will tell you, this is the first time someone's raised this issue in a zoning hearing.
Let's make certain he gets an award here.
Yeah.
Give him a medal.
Waiting for my hugs.
Okay, with no small reluctance, I'm going to support this thing now.
Commissioner Wayne?
So with what I've heard today, and when County Attorney, you've addressed the issues and concerns as far as public notice, we're making a decision on use. Development will come later in the future. With that in mind, I'll make the motion to approve.
Second.
We have a motion, we have a second. Any other discussion? Any objections? Motion carries. Thank you. Next case, Anthony.
All right, Commissioners, next and final case this morning is DCI 2021-00020, the Gator Domestic Industrial Center, IPD. I'm going to introduce to you Earl Hahn, Principal Planner with the Zoning Section, who will provide the staff summary and be available for any questions. Earl?
Good morning, Mr. Chairman, members of the board, ladies and gentlemen. My name is Earl Hahn, and I'm one of the 2 new principal planners that were hired by the zoning section last year. So today's case is a Gator Domestic Industrial IPD. The case number is DCI 2021-00020. And this application proposes to reduce industrial development from 900,000 to 700,000 square feet and to repeal 3 traffic-related conditions. So here's the aerial showing the location of the subject property, and you can see that it's more than a half mile away from Alico Road. This is the master concept plan. You can see that the property is firmly within an industrial area, and the same thing in the land use. And this was heard by the hearing examiner, who recommended approval subject to some conditions. And staff supports the hearing examiner's recommendation. There were 4 participants at the hearing. I'd be happy to answer any questions you may have.
I have a question real quick before we get to, so based upon the overhead here, can you point out what access to the property will be at? Will it be on Gator Road, or which roads will be access to that for the main entrance out to Alico?
So the main road will be Domestic.
Okay.
I mean, I'm sorry, Gator. And the reason is because there's an intersection there.
Yes, we installed the light there a couple years ago.
That's correct.
So there will be access in Gator Road.
Right, and that's one of the conditions that's being removed, is to require them to build, to install a traffic signal there.
So they're reducing from 900,000 square feet to 700,000. What's it going to be used for?
There's various industrial uses that are going to be used for that. If you go back to the
Any questions from staff yet?
the industrial, you can see they have a number of uses here along that they're proposing here. Warehouses.
The same for the record. Any questions for staff before they call the participants up? No? Okay, thank you.
You're welcome.
We have 4 participants of record. We'll call William Dubman up. Bill here. Kelly Hurt. Yes. Please come forward. You have 5 minutes to speak. You good? Okay. Kenneth Lee. And Mark Wiles. Mark's here. Good morning.
Good morning. My name is Mark Wiles. Hope everybody's doing well today. I own Wayne Wiles Floor Covering, and we've been on the south end of Gator since 1990. The property that is being proposed on the north end of Gator is about half of what the property is that's available, and I'm assuming that in the future maybe someone's going to develop that also. Gator Road is a private road. It's maintained by basically the owners on Main Line and south. The proposed property size that is being added is about the same size as the property that we are there now that's been developed. Okay, we maintain that road. We've been maintaining that road. I have unfortunately been the president of the Homeowners Association, Road Association since 1990, and I appreciate the help of getting that road paved, getting lights in. We certainly need all that stuff. In 1990, Alico Road was a 2-lane road with Australian pines when we moved in out there. Things have sure changed, okay? So I'm not opposed to the turn lane. I think that we need help, especially since Amazon has moved in just to the east of us. All of the Amazon traffic is going down Main Line, coming down Gator. Gator Road is an extremely busy road today. There are a lot of little gray vans running around out there and big semis. The effect that it's had on me and my business on that road has really affected me to be able to get out of my small little complex to get onto Gator, to get to Alico. I wish there was a way that something could happen with domestic to help Amazon out, because they're sure pushing a lot of wheels and people out there 24/7. So I'm here just to you know, the developers of the proposed property to the north of us are not interested in being involved in our homeowners association. They've really made no effort of that. I wish that whatever was happening to the north of us, that'll eventually be in the next few years, because I'm sure the growth on the piece north of what they're trying to develop is going to only come up in the future. I know there's no control and you can't make people join into an association, but you know, you've got a small group of people that are maintaining that road, and with Amazon and what's proposed, it's a big issue for us homeowners that are there, that are maintaining and taking care of the road. I can't thank all of you guys for everything you've done for you know, our area. I think you guys are all doing a great job, and I appreciate it, but I wanted to come up and state where I'm at from being there for, you know, 32 years now. It's you know, it's great to live in Southwest Florida. There's been a lot of development out there, and you know, we need you guys' help to help us out there with the traffic and what's going on. We are definitely in need of a turn lane on Gator, and I see traffic just continuing to get busier, as you guys do too. Okay, so I just want to come and state that. I appreciate everybody's time and allow me to get up and say that. Okay, all righty. Thank you very much.
Okay, that's the last public comment we have on this case. We'll come back to the applicant if they wish to address the board.
Good morning for the record. Al Quattrone with Quattrone & Associates. I didn't prepare a presentation, but I'm here to answer any questions if you have any on the project.
Like the presentation?
Just curious about the cost share that the hearing examiner said that she cannot allow, or the law does not allow her to do that, but your client is offering to do what? Explain to me that. And then what's he going to do since she's not going to allow it in this motion?
Yeah, so the original condition was to put the sole burden of building a turn lane on our client at his full expense with no participation from anybody else, which was logistically very difficult of having to deal with the railroad. One of the issues is the railroad crossing is over there. It's limited. Our client had originally offered to pay a pro rata share of what the turn lane would be if that developed. He wasn't supportive of actually joining the association because of the unknowns associated with it, and also the fact that joining the association wasn't addressing the condition that was imposed on him. So, I mean, he was willing to financially participate on a pro rata share if that's what it came down to. He just didn't want to pay 100% of it and be solely responsible for figuring out how to permit it either.
So who's going to pay what amount? Is he then now forced to take the alternative of joining the little group? And
no, I don't think the recommendation of staff or the hearing examiner isn't that he's forced to join.
How are the improvements going to be paid for?
I don't know. I mean, like I said, it's a private road.
Is that going to come in the development order?
Yes, sir.
Same issue we had.
I'll say no more.
Same issue we had in case one.
Any other questions for staff or for the applicant? I have a question. I guess it's more or less for staff. And Dave, maybe you can answer. So in a condition like this in the future, the development order is granted either way on this property or the one we just heard before. And if the other property owners decide we're not going to maintain the road anymore, we're just going to let it go. We're just going to let it go. and you got this new guys building, you got 3D glass over here, they got all their investment, their new place over here, you have other investors, obviously property owner's been there for 30 years. They said, we're not gonna maintain the road anymore, and obviously we're not gonna maintain it because it's a private road, the county can't. How would they, it's basically a civil between those parties of those property owners to get someone to pay equally?
Yes, that, they could work that out through a mutually beneficial agreement. They could choose to utilize the county's MSTBU process and establish an MSTU that everybody would be part of to assess themselves to pay the cost of maintenance.
Or they all could agree 50+1 to have the county just take the road over, bring it up to standards, right?
Yes, they would have to bring it up to county standards, I think, before the county would agree to accept it for maintenance, but that would be up to the board ultimately.
During the development order stages, could the staff then require the new applicant to do traffic improvements like the turn lane? I know it would be costly with the intersection. We dealt with the intersection with the Seminole Gulf Road with the train tracks there, but could they require those based upon the traffic concurrency to do some improvements to the traffic in the area?
Given their distance from Alico Road, and that's one of the reasons they downscaled their project a little bit to reduce their traffic impacts, I think they would only be responsible for any entrance improvements that they would have to do, and not all the way down at the Gator Road, Alico Road intersection.
But if that's their only access, though, that would be the main point to get in or out of their property, no matter how far away it is from the property, they still have to go through that intersection to get to it.
That is true. And
I'm just thinking, does that staff look at that based upon the traffic conditions and traffic analysis to see if they determine if they need to do those improvements through the development stages?
well, again, the responsibility for maintaining the road and the responsibility ultimately for improving the road is going to be on the private property owners that are responsible for the road at this point. So we have originally had a condition that required this property owner to be responsible for the turn lane, but that was based on a larger project with more impact. At this point, we don't have a basis for requiring that.
Thank you. Any other questions for
Just
staff?
thinking out loud, trying to help, some of the folks in that association who clearly have a really legitimate concern here. So if they went through the county's MSTBU process, they would only need to get 50% +1 of the property owners along this stretch to agree to the MSTBU, but then everybody, all the properties would be assessed, even those that opposed it, correct?
Typically, yes.
So that would get everybody along that whole stretch to contribute to whatever improvements then that the MSTBU wants to make.
Right.
Okay. So I mean, so there's a strategy right there to get even people who are reluctant to join an association, then maybe could join, as long as 50% +1 agree to it, everybody's then on board for helping to pay for those improvements. Okay.
That also would take a lot of pressure off, like Mr. Wiles, who's being having to be the president of that association or chairman of that group, to have to go around and try to get that down, because I know it's the hardship to do that when you're in charge of a group like that, trying to get everybody together. Any other questions?
Just one other comment. I mean, and Commissioner Hammond hit where I was going to go. In Sanibel, an awful lot of private roads, and homeowners really get to a certain point where really don't want the responsibility. So it's been very commonplace to have a vote, go to 50-some-odd%, and then the city be responsible in the same mechanism of collecting the necessary funds, and obviously maintaining that. Just a responsibility. I think your suggestion, Commissioner Hammond, is exactly what I'm very comfortable with and commonly done, in the private room conversions when we're in Sanibel. It happened very often.
Thank you.
Just a comment, I think that when we look at this area, it's a work in progress. It is what it is, what it was, what it is today, and going forward. And I agree with Commissioner Hammond. I think as long as we can provide an alternative looking forward, that alleviates the problem, brings people together, and there's a mechanism to do that, which we have. And I think that we're okay with it. It's a shame to lock it into a situation where there is not an exit strategy of some sort. So I agree.
Well, the good thing for the traffic, they actually reduced from 900,000 feet to 700,000, so the use has been reduced. That's a good thing. Okay.
Motion.
Is that motion, Commissioner Mann, for approval?
Second.
We have a motion, we have a second. Any other discussion? Any objection? No objection, motion carries. Thank you. We are adjourned. That's the last case.